Welcome back. So, in today's webinar, we are going to review the last two topics regarding Module 1, Webinar 1, Regulation of the Legal Profession Overview. In Part 1, we reviewed the first four, and in the second webinar, Part 2, we reviewed the next four, and today we are going to be going over these two. Responsibilities of partners, managers, supervisory, and subordinate lawyers, as well as restrictions on the right to practice. So let's get into it. And so let's start here with this one. And we're going to talk about, like I said, responsibilities of partners, managers, supervisory, and subordinate lawyers. And this topic concerns how professional responsibility operates inside a law firm or other legal organization. The MPRE frequently gives us situations involving partners, managing attorneys, supervisors, and associates. So the central question here is, when can one lawyer become professionally responsible for misconduct committed by another lawyer? And the starting point is important. A lawyer is not automatically responsible for every ethical violation committed by another lawyer in the same firm. Professional discipline is not simply based on organizational hierarchy. So the fact that you're a partner does not mean that every violation committed by every associate automatically becomes your violation. Instead, what the model's rules do is they impose different obligations depending on the lawyer's position, authority, knowledge, and involvement. And so let's begin with partners and lawyers who have managerial authority. So, under the model rules, these lawyers must make reasonable efforts to ensure that the firm has measures in place giving reasonable assurance that lawyers in the firm comply with the rules of professional conduct. And here, the key phrase is reasonable efforts. So, keep that in mind, reasonable efforts. So, imagine a law firm with hundreds of attorneys. The managing partners cannot personally monitor every email, every client meeting, every trust account transaction, and every litigation decision. And that is not what the rules require. Instead, management needs to establish reasonable systems and procedures designed to promote compliance. Depending on the firm, that could include procedures for checking conflicts of interest, protecting confidential information, supervising client funds, reviewing deadlines, training lawyers on professional obligations, and addressing ethical problems when they arise. What counts as reasonable depends on the circumstances, including the size and structure of the firm and nature of its practice. A two-lawyer firm like the one that I have here in Costa Rica will not necessarily require the same compliance infrastructure as an international firm with thousands of lawyers. So the obligation here is one of reasonable preventive management. Let's move on to the next one. Let me highlight it for you guys. So let's move from managers to direct supervisors. A lawyer who directly supervises another lawyer must make reasonable efforts to ensure that the subordinate lawyer's conduct conforms to the professional rules. So, suppose a senior attorney directly supervises a junior associate on a complex litigation matter. The supervisor cannot simply assign the matter and completely ignore how the associate is handling it. The level of supervision required will depend on the circumstances, including the associate's experience and the nature of the work. A newly admitted lawyer handling an unfamiliar matter may require significantly more supervision than an experienced associate performing routine work. Again, the standard here is reasonableness. Notice the distinction between the first two rules. A managerial lawyer has a broader responsibility to establish reasonable systems and procedures with the organization, and a direct supervisor has responsibility for making reasonable efforts concerning the conduct of the particular lawyers that person supervises. And let's move on to the next one. Now, here, a lawyer may be responsible for another lawyer's misconduct. And so here we reach a different question. When is a lawyer actually responsible for another lawyer's specific misconduct? There are several important situations. First, a lawyer is responsible if the lawyer orders the misconduct. Suppose a supervising attorney tells an associate, I know these documents are responsive to discovery, but don't produce them. Hide them from opposing counsel. The supervisor cannot later say, the associate was the person who actually withheld the documents. The supervisor ordered the conduct and can therefore be professionally responsible. Second, responsibility can arise when a lawyer knows about the specific misconduct and ratifies it. Ratification essentially means approving or adopting the conduct after learning what happened. So let's suppose a situation. An associate improperly contacts a represented opposing party. The supervising attorney later learns exactly what happened and approves the associate's conduct. The supervisor may become responsible because the supervisor knowingly ratified the misconduct. There is also another extremely important situation: failure to take reasonable remedial action. So, suppose a partner or direct supervisor learns about misconduct while its consequences can still be avoided or mitigated. The lawyer must take reasonable remedial action. For example, imagine an associate accidentally sends confidential information to the wrong person. The supervising attorney discovers the mistake almost immediately, while there still may be steps available to limit the consequences. The supervisor cannot simply ignore the situation. If reasonable remedial measures are available, the supervisor has an obligation to act. This distinction is frequently tested. So we ask, first, when did the supervisor learn about the misconduct? And second, could anything still have been done about it? If the misconduct was completely finished and its consequences could no longer be avoided or mitigated before the supervisor learned of it, the analysis may be different. And let's move on to the next one. Let me highlight it so we know where we're at. Subordinate lawyers remain independently responsible. So we're going to look here at the subordinate lawyer. This is where the phrase, I was just following orders, becomes important. Under the model rules, a subordinate lawyer remains bound by the rules of professional conduct even when acting at the direction of another lawyer. So, suppose a partner tells a junior associate, destroy this document before it hurts our client's case. The associate knows that destroying it would violate the professional rules. Can the associate do it simply because a senior partner gave the instruction? No. A supervising lawyer's instruction does not give a subordinate lawyer immunity from professional responsibility. The subordinate lawyer remains independently responsible for complying with the rules. So, when the ethical rule is clear, following orders is not a defense. Both lawyers, it's important, both lawyers may potentially face professional discipline. The supervisor for directing the misconduct and the subordinate for knowingly participating in it. Now, let's move on to exception for arguable ethical questions. So there is an important exception. A subordinate lawyer does not violate the rules when the subordinate acts in accordance with a supervisor's reasonable resolution of an arguable question of professional duty. Let's unpack that. So, professional responsibility questions are not always clear. Sometimes the applicable rule genuinely permits more than one reasonable interpretation. Suppose an associate and supervising partner disagree about whether particular documents must be produced in response to an ambiguous discovery request. Both analyze the applicable rules. The issue is genuinely debatable. The supervising attorney makes a reasonable determination that the documents do not need to be produced, and the associate follows that decision. A court later determines that the documents should have been produced. That does not necessarily mean the subordinate lawyer violated the professional rules. Why? Because the ethical question was arguable, and the subordinate followed the supervisor's reasonable resolution of that question. But compare that with an instruction to destroy evidence, lie to a tribunal, or knowingly disclose protected client information when the rule clearly prohibits the conduct. There is no genuine arguable question to resolve. A supervisor cannot transform clearly prohibited conduct into an arguable ethical question simply by instructing a subordinate to do it. So the distinction is clear violation. Following the supervisor's instruction is no defense. Arguable professional duty question. Following the supervisor's reasonable resolution may protect the subordinate from discipline. And let's move on to the last part here. For MPRE purposes, I want you to analyze these questions according to the lawyer's role, knowledge, authority, and opportunity to act. If the lawyer is a partner or manager, ask, what reasonable compliance systems and safeguards established? If the lawyer is a direct supervisor, ask, were reasonable efforts made to ensure that the subordinate complied with the professional rules? If another lawyer actually committed the misconduct, ask, did this lawyer order it or knowingly ratify it? And if the lawyer learned about the misconduct later, ask, were the consequences still capable of being avoided or mitigated? And did the lawyer take reasonable remedial action? Finally, if we're dealing with a subordinate lawyer, ask, was the subordinate simply following an instruction to commit a clear violation? If so, that is no defense. Or was the subordinate following a supervisor's reasonable resolution of a genuinely arguable question of professional duty? If so, the subordinate may not have violated the rules. So on the MPRE, don't stop after identifying the person who physically committed the misconduct. Look through the hierarchy. Determine who had responsibility, who knew what, who gave the instruction, who approved the conduct, and who still had an opportunity to prevent or mitigate its consequences. Now, we're going to move on to an MPRE practice question. So let's read the question for us. It's about supervisory and subordinate lawyers. So here, a partner instructs an associate not to produce certain documents in response to a discovery request. The request is ambiguous, and after reviewing the applicable rules, the associate reasonably believes that either interpretation is defensible. The partner reasonably concludes that the documents need not be produced, and the associate follows that instruction. The court later determines that the documents should have been produced and that withholding them violated the professional rules. So the question here is the associate subject to discipline? Now, what we're going to do is we're going to apply the rules of supervisory and subordinate lawyers. This question tests a very important distinction under the model rules. We learned on the previous slide that a subordinate lawyer generally remains independently responsible for complying with the rules of professional conduct. Like we said, in other words, my supervisor told me to do it. That is generally not a defense, but there is an important exception. A subordinate lawyer does not violate the professional rules by acting in accordance with a supervising lawyer's reasonable reasonable resolution of an arguable question of professional duty. And that exception is exactly what this question is testing. And so let's look carefully at the facts. The partner instructs the associate not to produce certain documents right here. Now, if the facts told us that the documents were clearly required to be produced and that both lawyers knew withholding them was prohibited, this would be relatively straightforward. The associate could not knowingly violate the rules simply because a partner ordered it, but those are not the facts. Here, the discovery request is ambiguous. That's very important. So the associate actually reviews the applicable rules. And after doing so, the associate determines and believes that either interpretation is defensible right here. Very important. The partner then makes a reasonable professional determination that the documents do not need to be produced. Those facts tell us that we're dealing with an arguable question of professional duty. The fact that a court later disagrees with that interpretation does not automatically make the subordinate lawyer professionally responsible. So let's look at the answers here. Answer A. Yes, because subordinate lawyers are always responsible for conduct that violates the professional rules. This is incorrect. There is a true principle hidden inside the answer. Subordinate lawyers are generally bound by the rules of professional conduct, even when they act under the direction of another lawyer. But the word always makes this answer incorrect. And like we talked, when you see words like always, analyze it very closely. And so when a professional responsibility is genuinely arguable, the subordinate lawyer may follow the supervising lawyer's reasonable resolution of that issue. And this is exactly what happened here. So answer A states the general rule, but ignores the exception. Now let's consider B. Yes, because a supervisor's instructions can never protect a subordinate lawyer from discipline. This is also incorrect. Again, the problem is the absolute language. If the partner tells the associate, destroy these documents so opposing counsel cannot obtain them, and the associate knows that doing so is prohibited, the associate cannot escape responsibility by pointing to the partner's instruction. But that is different from a situation involving a genuinely debatable ethical question. Here, the discovery request is ambiguous. So the associate analyzes the applicable rules, and the partner adopts a reasonable interpretation. So the model rules specifically recognize that a subordinate lawyer may rely on a supervisor's reasonable resolution in that situation. Therefore, answer B is incorrect. Now let's look at C. No, because the associate followed the supervisor's reasonable resolution of an arguable question of professional duty. This is the correct answer. There are two elements here, and I want you to recognize both. First, the question of professional duty must actually be arguable. That means there must be genuine uncertainty about what the professional rules require. Second, the supervisor's resolution of that question must be reasonable. We have both elements. The discovery request was ambiguous. The associate researched the issue. The associate reasonably concluded that either interpretation was defensible, and the partner reasonably determined that production was not required. So even though later the court disagreed, the associate falls within the protection provided by the model rules. Therefore, C is correct. And finally, let's look at D, where it says no, because subordinate lawyers are not professionally responsible for decisions made by supervising lawyers. This is incorrect. The answer goes much too far in the opposing direction. Subordinate lawyers may remain independently bound by the professional rules. Hierarchy within a law firm does not transfer all ethical responsibility to the supervising lawyer. And so imagine that a partner tells an associate, I want you to knowingly make this false statement to the court. The associate knows the statement is false. Could the associate respond, I'm not responsible because the partner made the decision? No. The subordinate lawyer cannot knowingly participate in a clear professional violation merely because a supervisor instructed the lawyer to do so. So answer D incorrectly creates a general immunity for subordinate lawyers that does not exist. And so, like I said, the correct answer is C. We start with the general rule. Subordinate lawyers remain responsible for complying with the professional rules and then ask, is the ethical obligation clear or is there a genuinely arguable question of professional duty? If the obligation is clear, following orders is not a defense. But if the question is genuinely arguable and the supervisor adopts a reasonable resolution, the subordinate lawyer may follow that resolution without violating the professional rules. And there's one final point worth noticing. The fact that the court ultimately decided that the documents should have been produced does not by itself determine whether the associate violated the model rules. The MPRE is asking us to evaluate the associate's conduct based on the circumstances and the reasonableness of the ethical determination when it was made. So when you see a subordinate lawyer question, ask, was it simply in order to commit a clear violation, or was this a reasonable resolution of a genuinely arguable ethical question? And that distinction will usually lead you to the correct answer. Now, let's move on to the restrictions on the right to practice. Let me highlight this, grab a little coffee. Okay. So, our final substantive topic in this module is restrictions on the right to practice. The basic principle here is that lawyers generally cannot enter into agreements that restrict their ability to practice law after a professional relationship ends. So let's begin with the most common situation, a lawyer leaving a law firm. So imagine a law firm hires an associate and includes this provision in the employment agreement. If you leave this firm, you may not practice corporate law anywhere within 100 miles of this office for 2 years. And many other industries, we might analyze that as a traditional non-compete agreement. But the legal profession has a specific rule. A lawyer generally may not participate in an employment, partnership, or similar agreement that restricts the lawyer's right to practice after termination of the professional relationship. So, this type of restriction would generally be prohibited. The prohibition is also broader than simply saying you cannot practice law after leaving this firm. A narrower restriction can still violate the rule. For example, you may continue practicing law, but you cannot practice family law for 3 years, or you may practice law, but not within the state, or after leaving the firm, you may not represent clients that you previously represented while working here. Each provision restricts some aspect of the lawyer's future practice. So on the MPRE, we need to look beyond traditional non-compete language. A restriction based on geography, practice area, particular clients, or another aspect of future legal practice can raise an issue. Now, let's move on to the next one. The rule protects client choice and lawyer mobility. Now, we need to look at why the professional rules generally prohibit these agreements. And there are two important interests. The first is lawyer mobility. Lawyers should generally remain free to leave one firm and continue practicing their profession. But the second interest is particularly important: the client's freedom to choose counsel. Suppose you've represented a client for 10 years and developed a strong professional relationship. You leave your firm. Naturally, and what usually happens is the client wants to continue working with you. If your former firm could enforce a non compete, preventing you from representing that client, the agreement would not only restrict your professional mobility, but it would also interfere with the client's ability to select the lawyer of the client's choice. That policy explains why restrictions on lawyers are treated differently from many ordinary commercial non compete arrangements. So, when you see one of these questions on the MPRE, don't analyze it solely as a contractual dispute between a firm and a departing lawyer. Professional responsibility also considers the effect of that restriction on clients and their access to counsel. And let's move on to the next one. Retirement benefit agreements are an exception. As always, the general prohibition has exceptions. One involves retirement benefits. The model rules permit certain restrictions concerning benefits upon retirement. And this makes sense when we consider the nature of the arrangement. A lawyer who is genuinely retiring may receive retirement benefits under an agreement connected with withdrawing from practice. This is treated differently from an ordinary employment agreement that attempts to prevent a departing lawyer from competing while the lawyer intends to continue practicing. So, imagine a law firm's retirement plan provides benefits to a partner who retires from the practice of law. The fact that receiving those retirement benefits is connected with retirement from practice does not automatically make the arrangement an impossible restriction. For MPRE purposes, when you see a restriction connected specifically with retirement benefits, recognize that the general prohibition may not apply. Now, on to the next one. Sale of a law practice is also an exception. So, let's suppose a lawyer has built a practice over 30 years and decides to sell it to another attorney. The purchasing lawyer is paying for the value of that practice, including its goodwill. If the selling lawyer could immediately open an identical practice next door and compete for the same clients, the transaction would be difficult to structure meaningfully. For that reason, the rules governing the sale of a law practice permit certain restrictions on the seller's future practice. A lawyer selling a practice may agree to cease engaging in private practice or in a particular area of practice within the geographic area in which the practice was conducted. So here we have an arrangement that would look very different if it appeared on an ordinary employment agreement. So we need to imagine these two situations. First, if you leave our firm, you cannot practice family law in the city for 3 years. That is generally an impermissible restriction on a departing lawyer. Now compare. As part of selling your family law practice, you agree to cease practicing family law within the geographic area in which the practice was conducted. Now, here we have a recognized exception connected with the sale of a law practice. So once again, our MPRE analysis is general prohibition first, then we ask if an exception applies. And settlement agreements cannot restrict a lawyer's future practice. We're going to move on to a different context here where restrictions on practice can appear. Settlement agreements, and this is extremely important. A lawyer may not offer or make an agreement in which settlement of a client's controversy includes a restriction on the lawyer's right to practice. So, imagine a lawyer represents a client in a product liability action against a manufacturer. The manufacturer offers a very favorable settlement, but adds this condition: will pay the settlement only if the client's attorney agrees never to represent another claimant against our company. That is a problem. The defendant is effectively using settlement of one client's case to remove a particular lawyer from representing future clients. That affects both the lawyer's future practice and the ability of future clients to obtain counsel with relevant experience. So, the plaintiff's lawyer cannot simply agree to the restriction because doing so would obtain a favorable settlement for the current client. And notice that the rule can affect lawyers on both sides of the negotiation. A lawyer may not improperly offer such a restriction, and a lawyer may not improperly accept one. So, if the defense counsel proposes the restriction, defense counsel may have a professional responsibility problem. If plaintiff's counsel agrees to it, plaintiff's counsel may also have a professional responsibility problem. This makes settlement restrictions particularly useful for MPRE questions because the exam can test the conduct of either lawyer. Now let's look at our MPRE focus. For MPRE purposes, when you see an agreement limiting a lawyer's future practice, start with the general rule. Restrictions on a lawyer's right to practice are generally prohibited. Then identify the context. If this is an employment, partnership, or similar agreement, ask, does the agreement restrict what the lawyer may do after the professional relationship ends? Look for restrictions based on geography, practice area, particular clients, or other limitations on future legal practice. So, if this is a settlement agreement, we need to ask, is settlement of the client's matter being conditioned on limiting the lawyer's ability to represent other clients or otherwise practice in the future? If so, that should immediately raise a rules issue. And finally, check for the recognized exceptions we've discussed. Number one, is the restriction connected with certain retirement benefits, or is it connected with the sale of a law practice? If neither exception applies, return to the general prohibition. So the NPR framework is this: general prohibition, identify the restriction, identify the context, check for an exception, and remember the policy behind the rule. It does not merely protect lawyers from restrictive agreements, it also protects something fundamental to the client-lawyer relationship, the client's freedom to choose legal counsel. And last but not least, let's move on to the MPRE practice question regarding restrictions on practice. So we're going to look here, and I'll read it first. An attorney represents several clients in product liability claims against a manufacturer. The manufacturer offers to settle one client's claim on favorable terms, providing that the attorney agrees not to represent any future clients in claims against the manufacturer. The client wants to accept the settlement and asks the attorney to agree to the restriction. And the question is, may the attorney accept the restriction? So, here the question places the restriction inside a settlement agreement, which is one of the contexts you should immediately recognize on the MPRE. Let's identify what is happening. First, the attorney represents a client against a manufacturer. Second, the manufacturer is willing to offer the client favorable settlement terms. But there is a condition. They are saying that the attorney must not agree to represent future clients against that manufacturer. And so that's very important here. So here's the important thing. The current client wants the attorney to accept the condition. So we have competing considerations. On one hand, the attorney has an obligation to act in the interest of the current client, and the client wants a settlement. On the other hand, the model rules places an independent restriction on agreements that limit a lawyer's future practice. So the question is whether the client's preference changes that rule. It does not. Let's analyze each answer. So let's go look at first, of course, answer A. Yes, because the restriction is part of a settlement that the client wants to accept. This, of course, is incorrect. And this is probably the most tempting answer because the client is the person whose case is being settled. Normally, the decision whether to accept a settlement belongs to the client. And if the client considers the financial terms favorable, we might initially think the attorney should follow the client's instructions. But there are really two different decisions here. The client may decide whether to settle the client's claim, but this settlement cannot properly require the lawyer to accept a restriction on the lawyer's right to practice. The client's consent does not eliminate the lawyer's independent professional obligations under the model rules. So even if accepting the restriction would help the current client obtain a favorable settlement, the attorney cannot agree to an otherwise prohibited restriction on future practice. So, of course, answer A is incorrect. Let's move to answer B. Yes, because the restriction concerns only representation against one particular manufacturer. This, of course, is also incorrect. A restriction does not need to prohibit the attorney from practicing law entirely. Remember what we discussed on the previous slide. A limitation can restrict a lawyer's practice by geographic area, practice area, particular clients, or particular types of matters. And here, the attorney would remain free to practice law generally, but the attorney would no longer be permitted to represent future clients against this particular manufacturer. So this is still a restriction on the attorney's right to practice. So in this fact, this scenario illustrates one of the policy concerns behind the model rules. The attorney apparently has experience handling claims against this manufacturer, and preventing the attorney from representing future claimants could reduce those future clients' ability to choose counsel with relevant experience. So the narrow scope of the restriction does not make it permissible. So answer B is incorrect. Now, let's go ahead to C. No, because a lawyer may not enter into a settlement agreement that restricts the lawyer's right to practice. This, of course, is the correct answer. So the model rules prohibit a lawyer from participating in, offering, or making an agreement in which a restriction on the lawyer's right to practice is part of the settlement of a client controversy. And that is exactly what we have here. The manufacturer is essentially saying, we will give your current client a favorable settlement if you agree not to represent future clients against us. The settlement is therefore being used to restrict the attorney's future professional activity. The attorney cannot accept that restriction. Therefore, C is the correct answer. And of course, let's see why D is incorrect like A and B. So D says no, because lawyers may never agree to any restriction on their future practice. The answer reaches the correct result, but the reasoning, of course, is too broad. The word never is the problem. As we discussed on the previous slide, the prohibitions on restrictions on practice has recognized exceptions. Certain restrictions associated with retirement benefits are permitted, and restrictions associated with the sale of a law practice may also be permitted. So it is incorrect to say that a lawyer may never agree to any restriction on future practice. So the restriction in our question is prohibited because it is being imposed as part of the settlement of a client's controversy, not because every possible restriction on a lawyer's future practice is prohibited without exception. Therefore, answer D is incorrect. And so I will highlight, of course, the correct answer, answer C. And this question gives us a useful MPRE lesson. Be careful when an answer choice uses a valid professional principle to justify something that another professional rule specifically prohibits. Here, the client wants the settlement. That fact matters, but client consent does not override every professional responsibility rule. The lawyer still has independent obligations concerning the structure of the settlement agreement, and the rules specifically prohibit using the settlement of one client's controversy to restrict the lawyer's future practice. So, for the MPRE, when you encounter this type of provision, ask, what exactly is the lawyer being required to give up? If the lawyer is being asked to stop representing future clients, to stop handling a particular category of cases, or otherwise restrict future legal practice as a condition of settling the current client's dispute, you should immediately recognize the problem. And don't forget to distinguish that from recognized exceptions, as we discussed earlier. A restriction connected with retirement benefits or the sale of a law practice is a different situation. So the final rule here to remember is a lawyer generally cannot trade away the lawyer's future right to practice as part of settling a client's case, even when the current client wants the settlement.